Dr. Fauzia Khan to move a motion for consideration of the Protection of Children from Sexual Offences Amendment Bill 2024. Dr. Fauzia.
Sir, I seek to move a motion to consider and further amend the Protection of Children from Sexual Offences Amendment Bill 2024.
आप इस पर बोलना चाहे तो बोल सकते हैं।
हाँ जी।
जी।
सर, बच्चा एक नाजुक से फूल की तरह होता है जिसे आवश्यकता होती है प्यार की, देखभाल की, पालन पोषण की, ममता की। सर, एक गुस्से भरे शब्द से जो भयभीत हो जाता है, एक तीखी नजर से जो मुरझा जाए, ऐसे बच्चे की जो राक्षस हैवानियत से नुकसान पहुंचा सकते हैं, नोच फाड़ कर सकते हैं, उन्हें कभी भी बख्शा नहीं जाना चाहिए। Sir, Nelson Mandela once remarked, there can be no keener revelation of a society's soul than the way in which it treats its children. Crimes against children reveal not only their suffering, but also the society's underlying failures. Sir, इसीलिए 2012 में यूपीए सरकार एक कॉम्प्रिहेंसिव पॉक्सो एक्ट लेकर आई थी, Protection of Children from Sexual Offences. This act has been extensively examined by several courts, experts, organizations, and other citizens who have been making several recommendations to make this act more relevant to times. Sir, accordingly, it was amended in 2019, and in 2020, POCSO rules came into implementation. However, there are always new reforms needed to keep pace with evolving situations and policies. So today we face several pressing threats. Number one is drug abuse. Drug-related crimes adversely affect communities and contribute to criminal activities, including those impacting children. Secondly, sir, digital exploitation. The rapid growth of digital technology has fueled the production and distribution of child sexual abuse material, causing lasting harm to victims. Number three, sir, juvenile offences are on the rise. Between 2021 and 2024, 1,681 minors were implicated in 1,061 criminal cases in Pune alone, with offences ranging from theft to sexual crimes under the POCSO Act. In 2022, sir, 37,780 juveniles were apprehended, with 78.6% belonging to the 16 to 18 age group. महाराष्ट्र के बदलापुर में अगस्त 2024 में एक घटना सामने आई थी जिसका बहुत पब्लिक रिएक्शन हुआ था। एक किंडरगार्टन स्कूल में एक मेल स्वीपर 2-4 वर्षों की बच्चियों को सेक्सुअली एक्सप्लॉइट कर रहा था और इसका बहुत पब्लिक आउटक्राई हुआ। शायद उस शैक्षणिक संस्था के कुछ काले कारनामे होंगे जो सामने आने का डर था, इसीलिए उस व्यक्ति जिसका नाम था अक्षय शिंदे, उसका एनकाउंटर कर दिया गया। सर, एक सिंगल मेंबर एनकाउंटर कमीशन बिठाया गया जिसकी रिपोर्ट 3 महीने में अपेक्षित थी और आज भी अपेक्षित ही है। सर, परंतु एनकाउंटर किसी समस्या का निवारण नहीं कर सकता है। एनसीआरबी पॉस्को केसेस increased by 94.47% in 6 years since 2017. The number of registered cases increased to 2,99,759 in May 2024, of which 1,62,497 were disposed of. This bill, sir, the Protection of Children from Sexual Offences Amendment Bill 2024, aims to address these challenges by introducing victim-centric reforms. The key objectives of this bill, sir, include addressing ambiguities in reporting offences and compensating victims, introducing clear and structured compensation procedures to prevent delays, mandating training for stakeholders, including educational institutions and childcare personnel, to ensure effective implementation. So, number one, reporting offences. Amendment to Section 19(6), reporting procedure for offences. Under the proposed bill, the police or the special juvenile police unit must present the child before the Child Welfare Committee and report the case to the special court or the sessions court if a special court is unavailable within 24 hours. This is a significant change as no specific timeline was previously mandated. Once the child is presented, the CWC will conduct an inquiry under the Juvenile Justice Care and Protection of Children Act 2015 to ensure proper investigation and support. Now, sir, why I have brought this change? Sir, because delays and coordination... Sorry?
उसको एक्ट में
Sorry?
1919 में संशोधन हुआ, फिर 20 में रूल्स बने. अब ये इसमें आप कारण जरा स्पष्ट करिए कि इन सब के बावजूद आप ये क्यों लाना चाहते हैं?
हाँ सर, मैं वही बोल रही हूँ कि
आप करें, आसन की ओर से आपको छूट है, आप अपनी जितनी बात रखना चाहें वो पूरी रखें.
हाँ, तो पूरी रख रही हूँ सर, और पूरी रखने के लिए खड़ी हूँ, और ये मैं जस्टिफाई करना चाह रही हूँ कि why this change I am proposing here in this bill. Because of delays and coordination gaps among police, CWCs and special courts worsen harm and increase the risk of repeated trauma for children. Sir, courts have frequently highlighted consequences of delayed reporting of child-related offences. In Shankar Kishan Rao Khade versus State of Maharashtra 2013, the Supreme Court addressed the rape and murder of a minor girl with intellectual disabilities and emphasized that failing to report sexual assault cases that involves minors amounts to shielding offenders and obstructing justice. The judgment described this as a societal issue where witnesses often remain silent due to stigma, fear or ignorance of legal responsibilities. Sir, stronger legislative mandates and enforcement mechanisms are essential to ensure timely reporting, confidentiality, and safeguards for whistleblowers. So this is my justification for this amendment. Amendment to Section 21(2), penalty for failure to report offences. So we have proposed a penalty for failure to report. The proposed amendment mandates that individuals in charge of institutions such as schools, colleges, and companies report any confirmed or suspected offences against children. Previously, the law only penalized the failure to report confirmed cases. The amendment extends this obligation to include potential offences, ensuring proactive intervention. Now, sir, why I'm proposing this change is, if you remember the Muzaffarpur shelter home case, it exposed severe failures in child protection, where young girls were sexually abused at a state funding shelter in Bihar. A social audit by the TISS uncovered these abuses in 2018, revealing that authorities ignored early signs of abuse. The proposed amendment to Section 21(2) addresses such systemic failures by mandating the reporting of both confirmed and suspected offences. Yes. International precedents also corroborate the need for this, sir. The US Child Abuse Prevention and Treatment Act mandates that institutions, including schools, hospitals, childcare facilities, report suspected child abuse. Sir, amendment to Section 25(2), statements made by children. Under the proposed amendment, a child's statement made before the Child Welfare Committee will be considered supplementary to the statement given before the magistrate. Why, sir? This amendment ensures that a child's voice is fully heard, with statements made before welfare authorities given appropriate weight. Sir, often children's testimonies may vary due to trauma, which can lead to lower conviction rates. Yes. By giving due consideration to statements made before the CWC, this amendment makes the trial more sensitive to the psychological impact on victims, sir. We have international precedents as well. The EU Victims' Rights Directive and Bill C2 in Canada allow recorded statements to be used in criminal proceedings, reducing the burden on victims and ensuring that their testimony is preserved accurately. Sir, importance in addressing online threats also is very important. Timely reporting combined with strict penalties for non-compliance will help institutions remain responsive to digital threats, particularly concerning the production and distribution of child sexual abuse material. So the next point, the next amendment which I have tried to make is compensation procedure. The proposed bill aims to establish a clear and structured procedure to ensure that victims of sexual offences, particularly minors, receive timely compensation without procedural delays or inconsistencies. To address these issues, Section 33 will be omitted and replaced with a new chapter 8A on compensation and financial aid. This chapter introduces provisions that grant victims a legal right to timely and adequate compensation. Under the proposed Section 38A, all victims will be entitled to final compensation regardless of whether the offender is convicted, acquitted, or remains untraceable. This provision ensures that no victim is denied financial assistance due to the outcome of the case. Under the current system, many victims receive no financial relief if a trial ends in acquittal due to insufficient evidence or hostile witnesses. For example, in cases of sexual abuse within families or close communities, victims may be reluctant to testify, resulting in acquittals. The new mechanism ensures that victims receive both interim and final compensation to support therapy, rehabilitation, and education, promoting long-term recovery. Secondly, juvenile offenders who are often treated with a focus on rehabilitation rather than severe punishment may receive lesser penalties, leaving victims without adequate compensation. Sir, under the proposed mechanism, minor victims of crimes committed by juveniles will be eligible for financial assistance to cover medical, psychological, and rehabilitation needs. For instance, a minor sexually assaulted by a 16-year-old offender can receive immediate funds, even if the offender is sent to a juvenile correctional facility. Thirdly, if the offender is financially incapable of paying, victims are generally left without support. The proposed system ensures that compensation is provided by the government through the District Legal Services Authority, removing dependency on the offender's ability to pay. For example, a victim of sexual harassment by a low-income offender would still receive assistance to cover legal fees, relocation, or mental health treatment. Section 38B empowers special courts to provide interim compensation at any stage after the registration of the FIR. This interim relief will be adjusted against the final compensation, ensuring victims receive immediate support without waiting for lengthy legal proceedings. The DLSA will oversee applications for compensation and must ensure that payments are made within 30 days of a recommendation from the special court or within 60 days of an application by the victim. Section 38D further specifies that the State Legal Services Authority will monitor compensation issues, resolve delays within 15 days, and ensure timely fund disbursement through proper tracking mechanisms and grievance redressal systems. So there is a case reference which I would like to quote. In Saibaj Nur Muhammad Sheikh versus the state of Maharashtra, the court emphasized the importance of awarding victim compensation, especially in cases involving bodily harm, sexual assault, and offences against minors and women. Additionally, Rule 9 of the POCSO rules allows special courts to grant interim compensation. However, the proposed bill will codify this provision into the Act itself, strengthening enforcement and eliminating reliance on delegated legislation. Additionally, special courts will be empowered to recommend additional compensation if the initial amount is deemed insufficient for rehabilitation. So, interim compensation will be helpful in cases like, number one, victims of child sexual abuse material and digital crimes face ongoing psychological trauma due to the continued circulation of their images online. Section 38B allows immediate disbursement of funds for psychological counseling and legal expenses. Number two, sir, the proposed bill ensures interim compensation to facilitate urgent rehabilitation, including medical care, counseling, shelter, and vocational training for victims, especially in cases of trafficking and drug abuse. Number three, sir, legal proceedings under the POCSO Act often take years to reach a verdict, during which victims face severe financial burdens. The proposed interim compensation mechanism ensures support to victims in such pertinent cases. For example, a victim involved in a prolonged trial involving sexual abuse at an educational institution could access funds for counseling and educational support to mitigate the impact of delays. So studies show low realization of compensation, with male and transgender victims facing even greater difficulties in receiving compensation. Number one, the provision for interim compensation will provide required support for this neglected segment. Yes. Number two, sir, additionally, the structural inadequacies of current special courts contribute to the victim's distress. Number three, sir, children often face intimidation due to inadequate separation from the accused. Yes. Sir, courts frequently lack separate waiting rooms, screens, or friendly environments, leading to additional trauma for victims. The Muzaffarpur shelter home case, the earlier cited 2018 Muzaffarpur case, sir, revealed systemic failures where minor girls were sexually assaulted within a government-funded institution. So many such victims face delays due to procedural loopholes. The proposed compensation system ensures timely intervention by empowering special courts to recommend financial aid for relocation, medical care, rehabilitation, without waiting for the investigation's conclusion, sir. And we also have international comparisons here. So Germany, OEG, Victim Compensation Act, guarantees state-funded compensation for medical and psychological rehabilitation. The UK Criminal Injuries Compensation Scheme provides structured state-funded compensation for victims. Hence, the proposed amendments aim to address existing gaps and ensure that compensation mechanisms are efficient, timely, and inclusive of all victims, promoting recovery and justice. Sir, my amendment number 3 is training for stakeholders. Section 43. Existing provision mandates periodic awareness campaigns and trainings for government and police officers. The proposed change is that heads of institutions, teachers, and others working with children must receive regular training on provisions of the POCSO Act. Childcare institution staff must undergo sensitization and specialized training to ensure effective implementation of the Act. So, educational personnel must be trained to understand and implement the provisions of the Act, enabling them to verify facts and lodge complaints effectively. This change is necessary because a lack of proper training among police officers, judicial authorities, and institutional caregivers has led to mishandling of cases and insufficient child-friendly environments. So, as per 2018 NLSIU report, in several instances, children were subjected to multiple rounds of questioning due to untrained investigators and police officials not adhering to child-friendly procedures. To address this, the National Commission for Protection of Child Rights has developed a comprehensive manual on safety and security of children in schools, offering guidance on ensuring child protection. Several sensitization programs for school authorities and staff have been conducted, focusing on creating safe school environments. Additionally, specialized approaches for victims with mental and physical disabilities must be incorporated, ensuring they receive appropriate care and support. So, training should be carried out for educational personnel to handle disclosures sensitively without causing secondary trauma. NCPCR has also compiled guidelines on cybersecurity safety to address the growing risk posed by online threats. Workshops on the POCSO Act child abuse reporting mechanisms such as POSCO, e-box, and emotional intelligence have been organized to equip teachers and students with tools to foster a supportive and protective environment for children. So this has to be widely done. International comparisons, Australia's child safe standards mandate the adoption of a child protection policies and regular audits in institutions to safeguard children effectively. Additionally, multiple studies have revealed a concerning lack of awareness among parents regarding the POCSO Act and their role in preventing and addressing child abuse. So, to close this gap, training programs should not be limited to school authorities and government officials, but should also target parents and guardians. So, I am concluding by saying that this bill is a significant step towards making the POCSO Act more victim-centric and effective. By addressing existing ambiguities, the amendments aim to improve the transparency and effectiveness of the implementation of the Act. Proper training for stakeholders, combined with a clear compensation and reporting mechanism, will ensure that child victims receive the protection, support, and justice they deserve, sir. At the end, I will only say, खरीद पाऊं खुशियां, उदास चेहरों के लिए, खरीद पाऊं खुशियां उदास चेहरों के लिए, मेरे किरदार का मोल इतना कर दे खुदा. Thank you, sir.